So good evening and welcome. My name is Alison Duxbury and I am the Interim Dean of Melbourne Law School, and it is my pleasure to welcome you tonight to the 22nd offering of the annual Law Book Lecture. Law Rare Book Lecture. I want to begin by acknowledging the Wurundjeri people of the Kulin Nation as the traditional custodians of the land on which we are meeting, and I pay my respects to their elders past, present and emerging. I extend this acknowledgement to all Aboriginal and Torres Strait Islander people joining us today. This lecture uses the unique library collection as a starting point to generate broader discussions on current legal matters. Tonight's lecture, Persuasion and Prejudice, Jane Austen and Lawyering, draws from the work of Jane Austen and the compelling link between her writing and a lawyer's need for empathy and other human traits in a world of artificial technology. Our speaker tonight is my colleague, Associate Professor Gary Cazalet. Professor Cazalet joined our law school 20 years ago after a 25-year career as a lawyer and solicitor, including 11 years at the Victorian Bar. His teaching areas include dispute resolution, court procedures and processes, legal ethics, public interest litigation, and law and literature. Significantly, he has a passion for the study and teaching of law and literature's entwinement. Professor Cazalet led the introduction of the popular law and literature subject at this law school, as well as our future lawyer subject, and I think there are probably a few students from those classes here with us tonight. He also leads on the hands-on law apps clinic that has students design technological solutions to disseminate legal information to real-world clients. These are exciting and popular subjects at our law school, and I thank Gary for his contributions to this teaching and the wider understanding of the links between the law and the society it serves. I was drawn to an article about Professor Cazalet in The Age, published in 2011, called "It's Law, but Strictly by the Book," written on his passion for the teaching of the relationship between law and literature. In this article, Professor Cazalet says, "A familiarity with the literary classics makes you a better person, and if you are a better person, then you are a better lawyer." Tonight, Professor Cazalet will discuss the role of lawyers amongst the rise of technology and artificial intelligence, arguing that the uniquely human skills of empathy, emotional intelligence, creativity, and self-knowledge will only become more important in the practice of law. In essence, Professor Cazalet will explore how reading Jane Austen can help law students and lawyers be better and happier lawyers. I should say that as part of this introduction to Gary, I was drawn to the part of the title of the lecture which begins with Persuasion and Prejudice. So I'm not sure whether we'll be hearing from Mr. Wentworth, Mr. Darcy, or Mr. Bingley. But Gary informs me before the lecture that he did not want to be introduced as Mr. Collins. There will be a chance to answer questions after this presentation. So if you have a question, please raise your hand during the Q&A session and a microphone will be brought to you. Before I hand over to Gary, I would like to acknowledge the extensive work of our law school librarian, Carol Hinchcliffe, and her team across the law collections, including our rare book collections. Carol will kindly offer some closing remarks following the Q&A. Just a reminder that tonight's lecture will be filmed and made available shortly after on the Melbourne Law School website. Now please join me in welcoming Gary Cazalet to the lecture. Thank you.
Thank you, Alison, for that introduction, and thank you, everybody, for coming. I can't believe it's 20 years. It's 20 years? You must have checked it up. In fact, this is the lecture theatre that I first gave my first lecture to a compulsory subject in the law school, and it had almost as many people in it. I started that lecture, which is kind of surprising now, looking back, with literature and I started with a haiku. So I think I probably should start with a haiku now to show you that I'm not Mr. Collins. If I was Mr. Collins, this lecture will now go for 4 hours and 32 minutes. And yeah, so I'm not. So I'm going to read from the book 100 Great Books in Haiku, and it is the haiku for Pride and Prejudice. Pride and Prejudice, Jane Austen. Single white lass seeks landed gent for marriage whist. No parsons, thank you. So that's the end of the lecture for tonight, and you can all go out and have a good dinner somewhere. But seriously, I would like to thank you for coming along and thank you for the invitation to give the annual law book lecture. I want to start, as Alison has started, with the way we start all of our lectures and classes at Melbourne Law School and throughout the university, which is an acknowledgement of country. I recognise that today we are on the lands of the Wurundjeri people of the Kulin Nation, and like Alison, I pay my respects to their elders past and present. Today's lecture is in part about storytelling, stories we tell ourselves and stories we tell others. A central feature of Jane Austen's Pride and Prejudice is the recognition by central characters that the stories that they have told themselves need to be reconsidered in the light of new evidence. It is, as I have already done, appropriate to start this lecture as I have by acknowledging that the original inhabitants of this land and the continuing owner of these lands are the Wurundjeri people. Earlier this year, the university published Doombak Gob Guana, A History of Indigenous Australia and the University of Melbourne, Volume 1, Truth. It's a volume that is available through the Melbourne University website as a free download. It records, by the three editors and writers of that book, the university's history with our Indigenous people in Australia and the owners of this land. I commend it to you. Larissa Brent has written in an article entitled Indigenous Storytelling, Decolonising Institutions and Assertive Self-Determination, Implications for Legal Practice, the following. Storytelling is ancient and potent. It is our most instinctive and human form of communication, of teaching, of persuasion, of validation, of healing, of transformation. It has a particular resonance in oral cultural traditions like those of Aboriginal and Torres Strait Islanders. She goes on to write, the Western tradition assumes neutrality or objectivity by a scholar and a researcher. It is suspicious of subjectivity. Indigenous approaches to knowledge are completely the opposite. They understand that where you are placed, your position or your standpoint will fundamentally influence the way you see your world. And I urge you to keep that in mind as we discuss, or as I discuss, Austen over the course of this lecture. She goes on to say, Indigenous standpoint notes up front that we as individuals are shaped by our cultures, cultural values and experiences with society's institution. And that is true no matter what background someone has, and it challenges those who do not reflect on the values, biases and assumptions they bring into their work. In this way, Indigenous standpoint theory plays an important role in challenging the assumptions around neutrality that are actually a way of reinforcing power structures of colonisation and patriarchy. So in that context, and while acknowledging how much probably everybody in the audience loves immersing themselves in Jane Austen and in Pemberley and the world of middle-class England and upper-class England, I want for a moment to just reflect on what was happening in Australia at that time that Austen was writing, when she was born and when she died. So she was born in 1775, 3 years before the arrival of the first fleet in Australia, onto a land that the law recognised for 200 years as being terra nullius. Pride and Prejudice was published in January 1813. Jane Austen died on the 18th of July 1817, and I don't suppose it was planned, but she was buried in Winchester Cathedral on this very day in 1817. So for all our love of Austen and the world she created, I just thought for a moment before we get into the Austen part of the lecture, just to reflect, as I said, what was happening in Australia at that time. So this is a copy of the Sydney Gazette, published on July the 19th, 1817. That is the day after her death. That is Austen's death. As we look at the Gazette and look at the next page of the Gazette, we can see there was a notice in there about Indigenous children, and I'll read. Agreeably to the notice requesting a meeting of the gentlemen forming the Committee of the Institution for the Civilisation and Maintenance of the Native Children, this meeting took place on Wednesday last at the Schoolhouse, Parramatta. The committee expected that the children should have made some progress and consequently entered into a very particular examination, the result of which proved highly satisfactory. The school now contains 11 girls and 5 boys who appear to be totally weaned from the manners and practices of their parents, all promising to testify by their future conduct and exemplary proof that the care and patronage bestowed upon them has not been idly lavished, but on the contrary that the difference of complexion imposed by the Almighty only was never intended as a proof of insusceptibility or incapacity to become useful to the general purposes for which man was created. I put that there so that we can reflect on the context that I'm speaking about tonight, about Austen's writing, but also the context of what was happening in this place that we call Australia now at that time, and to reflect on how, as we read, the context from where we're reading is important for our understanding of what we're reading. So moving to Pride and Prejudice by Jane Austen. It is a truth universally acknowledged that Jane Austen and her writing inspires a devotion and passion that seems, apart from Shakespeare, unequalled in English literature. And it's a truth that I should acknowledge at this outset, that books by and about Jane Austen are anything but rare. And on one view, this lecture should really be called the most common book lecture. All of Jane Austen's novels are available free of charge through Project Gutenberg. There are free versions available through the Amazon Kindle. Various editions of her letters are available either free or at low cost. But if you really wanted to spend a whole lot of money on a rare book, you could have a look on Aid Books now. I priced it last week. There is a 3-volume first printing set available of Pride and Prejudice for just US $225,000 plus $90 shipping. A search through the university's catalogue for the subject Jane Austen produces 764 entries on a variety of subtopics, such as Jane Austen Appreciation -Norway. Characters, Mr. Collins, at which point I would expect the audience to shudder or laugh or do all two at once. And then other works such as Expanding Austenland, the Pride and Prejudice Fan Fiction Archive. Exploring beyond the university's library catalogue becomes an endeavour fraught with danger. Unfortunately, I've done that over a number of months. Podcasts, films, plays, including one currently running at La Mama, diaries, parodies, music, etc., etc. And of course, central to the recollection of many people perhaps in the audience is the BBC adaptation of Pride and Prejudice, released, believe it or not, in 1995, many years ago. And of course, we've got Bridget Jones's Diary. So, with an enchanted sea of Austen's pleasures before me and the task of staying on topic and relevant to the intent of this series of lectures, I've chosen to focus on one book, one edition, and that is the Peacock edition of Pride and Prejudice, published by George Allen in 1894. That's it. I'll talk more about it a little later. It is from this edition that the illustration for this lecture was taken. And I'd like to just keep it rare between us all. But unfortunately, if you've got an iPhone or an Android phone or anything else in your pocket, just put in Project Gutenberg, put in Pride and Prejudice, and that image will come up, and you'll find that the entire edition is available on Project Gutenberg's website. But if you'd prefer a hard copy, you could go onto ABooks. I don't get any percentage of this at all, but you could buy a copy on ABooks for $13,140 US at the moment. This particular rare book, which you can see on Project Gutenberg, contains illustrations by the celebrated Victorian illustrator Hugh Thompson and a preface by George Saintsbury. I'm going to talk about that edition a little later on. So, to storytelling. I'm going to talk about storytelling. I'm going to speak about current and future legal work. I want to talk about what makes lawyers happy. And of course, because it's a rare book lecture about Pride and Prejudice, I'm going to be talking about Pride and Prejudice and this particular edition of Pride and Prejudice. First, a disclaimer. What I'm not dealing with is all of our other works. Nor am I going to talk about 19th century inheritance law. Some people are probably disappointed, so you can leave now, but I'm not going to be talking about 19th century inheritance law. There's lots of books and articles on 19th century inheritance law and entails and all of those kinds of things. The other disclaimer is I don't profess to be an Austen expert. I really enjoy Austen. I've enjoyed going through the sea of materials on Austen, but I'm sure that there are many members in the audience that know a lot more about Austen and her other works than I do. So, let's move to storytelling. The American writer Joan Didion was just as fond of a good opening line as Jane Austen. The opening line of Joan Didion's book of essays, The White Album, is, "We tell ourselves stories in order to live." I'm going to rework her statement by stating that stories tell us how to live. Stories are at the heart of our understanding of ourselves and the world. They are also at the heart of legal practice. Clients tell lawyers stories, and lawyers tell other lawyers and the public and courts stories. So for context, here's a little bit about my story. Before I started, 20 years ago apparently, at the law school, I was a barrister at the Victorian Bar, and before that I was a solicitor at a large national law firm. Stories have always been important to me. Stories of clients, stories in books and in conversation. It was serendipity that brought me here, and the person that actually invited me I can see in the audience tonight. I enjoyed most of my work as a barrister, but there were some things in the practice of law that disturbed me, and I thought and still think that things can be done differently. Perhaps the conduct that disturbed me most when I was in practice was how my colleagues, and no doubt myself, often overlooked or were blind to the concerns of clients that fell outside some kind of a legal framework. Speedy decision-making, getting to the point, sifting the chaff from the wheat are all those lauded attributes of a good lawyer, and probably for doctors, and I'll talk about that in a moment. Clients seek lawyers for answers, and answers we give. The faster, the better. It's been said that, quote, law sharpens the mind by narrowing it. This speed, this focus, this keyhole approach to legal practice may in certain situations be the best approach. However, this approach often means that the underlying issues and complaints are missed, leaving causes of conflict unresolved and disputes simmering, not to mention deep dissatisfaction by clients with the legal process. We may say to clients, that's not relevant. The court won't listen to that. Well, the court can't do that. And sometimes we just say it with a shrug of our shoulders and an apology that recognising that our legal system is not competent to deal with such concerns. Much of the curriculum of law schools, I may say, and the practice of law sometimes misses that understanding of a client's position and context. And you'll probably see where I'm going to about reading Jane Austen. Our eagerness to get to the bottom of the problem meant that we missed the wider picture. This approach isn't just confined to lawyers. In an article published in the Journal of Internal Medicine, the US Journal of Internal Medicine, the authors examined a diverse range of clinical encounters and concluded that the median time for a doctor to interrupt a patient's story was 11 seconds. Concern about doctors' decline in empathy led this university's medical school to introduce a narrative medicine course taught in part by Dr. Tony Birch, and I imagine a number of people in the audience have read Tony's work. Inspired by his work and his writing, I've asked him, and he does come to my future lawyer class, to teach about reflective practice and narrative. Professor Martha Nussbaum, the US-based professor, in her article Cultivating Humanity in Legal Education, argues, quote, "The imagination of human predicaments is like a muscle. It atrophies unless it is continually used. And the imagination of human distress, fear, anger, and overwhelming grief is an important attribute in the law. Lawyers need it to understand and depict effectively the plight of their clients. Judges need it to sort out the claims in the cases before them. Because this ability is frequently so underdeveloped in quick, competitive, highly intelligent people, the narrative imagination needs particular thought in designing the content of legal education." So she goes on to argue that students in law schools should study literature as part of their law degree. And since I started teaching here, notwithstanding the haiku that I used in this class apparently 20 years ago, we've studied in my classes such as legal ethics and law and literature, authors such as Ibsen, Helen Garner. We've looked at To Kill a Mockingbird, The Tall Man by Chloe Hooper, Antigone, Oscar Wilde, Kafka, Martin Luther King, Auden and Archie Roach. We haven't yet studied Jane Austen. But you might pick up where I'm going. Jane Austen is fabulous, as we all know, because that's why you're here. But there are many, many other authors that can help students and lawyers understand themselves and others. So now I want to talk about where legal work is now and where it might go into the future. So a brief look at AI, artificial intelligence, tech, and really what's left for us to do. So in a 2021 report to the Australian Council of Law Deans, the authors of that report noted that contemporary law graduates have broader and shifting requirements of integrating 21st century knowledge, skills and values than their peers in previous graduating cohorts. They noted the need for reflective practice and evaluating judgment. They noted that some of the commonly mentioned skills that were required were 1, emotional intelligence, 2, interpersonal skills, human logic, creativity, interdisciplinary, the enabler of collaboration skills, adaptability, resilience, design thinking, strategy, leadership, self-regulation, and empathy. Technology has been a central feature of legal practice for many, many years. When I was a reader at the Victorian Bar, I had a laptop computer. It was a long time ago. Prior to then, there were programs that were used, but perhaps not specifically written for lawyers and legal practice. When I was a solicitor, we adapted a library catalogue program for running cases. Nowadays, the Supreme Court expects lawyers to be proficient with technology. And as Alison's mentioned, I teach a law and tech subject here called Law Apps. Tech is used to manage litigation, legal research, review documents, discovery, make predictions, handle costs, manage legal practice. It's a multi-million-dollar industry. It's doing work that has been traditionally done by lawyers. So what about AI? And I'm going to make a distinction from technology to AI, artificial intelligence. IBM defines artificial intelligence as technology that enables computers and machines to simulate human intelligence and problem-solving capabilities. But as a good academic, I thought I should go to the source. I always tell my students to do that, so that's what I did. I asked ChatGPT. I said, "What is AI?" It tells me this. It refers to the simulation of human intelligence in machines that are programmed to think and learn like humans. These machines can perform tasks that typically require human intelligence, such as recognising speech, making decisions, solving problems, and understanding natural language. Key components include machine learning, natural language processing, computer vision, robotics, expert systems, and neural networks. Uh-oh, are we out of work? Many of these so-called abilities have been core business for lawyers for many, many years. And tests with AI have shown that often it can do those things that I've just listed much better than humans. Can I just ask in the room, how many people have used ChatGPT or some kind of AI like that platform? Okay, probably about a third. When I ask my classes, my students, every single hand goes up. Okay, every single hand of my students goes up. They've all used ChatGPT. When I ask them how often they use it, most of them would use it every day. So in May of this year, the Supreme Court of Victoria issued guidelines for litigants, responsible use of artificial intelligence in litigation. Those guidelines recognise that artificial intelligence can be useful in conducting litigation and is already used in search engines and information management systems. However, it noted generative AI and large language models, aka ChatGPT and similar, create output that is not the product of reasoning, nor are they a legal research tool. They use probability to predict a given sequence of word. Output is determined by the information provided to it and is not presumed to be accurate. Those programs are more likely to produce results that are inaccurate for the purposes of current litigation. Generative AI does not relieve the responsible legal practitioner of the need to exercise judgment and professional skill in reviewing the final product. One of my students in Future Lawyer did a presentation on artificial intelligence as part of his project, and he's given me permission to show a couple of slides from that. He asked how AI might imagine the legal profession and to provide some images of the legal profession. That's what it provided. For at least half or maybe more of the room, you can see that there are some issues here. And a moment's consideration shows the limitations of AI and its biases. But if it can do so much, what's left? And where might Jane Austen, Fitzwilliam Darcy and Elizabeth Bennet help us? So I went back to ChatGPT and I said, that's just not enough. What is it that we as humans can do that AI can't do? And this was the answer. Humans possess several capabilities with their minds that AI, at least in its current form, cannot replicate. 1, emotional intelligence. 2, abstract and creative thinking. 3, ethical reasoning and moral judgments. 4, consciousness and self-awareness. And 5, adaptable learning. I'm pretty happy about that. As a teacher and as a human being, that we've still got those things that we can do that AI can't do. And in my subject, Future Lawyer, that Alison mentioned earlier on, we study a number of these aspects. So what might the art of reading literature and reflecting on our reading, I'm going to try and move this slide because it's really horrible, that last slide. I'll talk about these in a minute. What can our act of reading literature and reflecting on our reading do to help us to develop these skills? So, leaving aside at the moment harnessing AI and tech for another lecture, I just want to speak briefly about what we know about being better and happier lawyers. And I'm going to suggest that a fundamental part of being a better and happier lawyer is the ability to understand oneself and to understand others. And as much as possible to have some congruity between who you are and what you do. And if this was a class of students, I'd ask you to take out your notebook and write down some thoughts about what makes you really happy. I don't mean soft serve or sushi, though that may make you really happy, but what really makes you happy in life and what makes you happy in work. In an article published in 2015 called What Makes Lawyers Happy? A data-driven prescription to redefine professional success, the authors detailed the results of a survey of lawyers and judges in related positions across 4 state bar associations in the United States. They picked rural areas and city areas and a pretty wide and diverse number of people. They had a working sample of 6,226 responses. And they were able to conclude that money, grades at law school, and prestige have limited value for the well-being of lawyers. They say a happy life as a lawyer is much less about grades, affluence, and prestige than about finding work that is interesting, engaging, personally meaningful, and focused on providing needed help to others. The data therefore indicate that the tendency of law students and young lawyers to place prestige or financial concerns before their desires to, quote, make a difference or serve the good of others will undermine their ongoing happiness in life. Now, for people probably as old as me or older than me, we probably know some of that stuff and are thinking, why did they need to survey 6,226 people to tell us that? But I use that and that reading in my class in Future Lawyer as one of the first readings. Because for many law students, they don't know that yet. They're worried about their grades, they're worried about having enough money, they're worried about paying off their law degree, etc. But at least it's some consolation to them to recognise that all of those things won't necessarily contribute to their overall happiness. So if a happy lawyer is for one from whom their work is personally meaningful and focused on providing needed help, what might we do as educators to assist our students reach such goals? And as I mentioned at the start of the lecture, we can look to stories because they tell us how to live. So let's just look at some books now. The first slide here is from the rare book reading room at the university, and you'll see there's Emma, Pride and Prejudice in the middle, and Mansfield Park. The edition that I'm going to be talking about from here on is the next one, which is described, if I get it right, as the Peacock edition of Pride and Prejudice. When Pride and Prejudice was first published in January 1813, it didn't have any illustrations. It was published in 3 volumes, and Jane Austen was pretty excited about receiving her first copy. She wrote to her sister Cassandra on Friday the 29th of January 1813. She wrote, "I want to tell you that I've got my own darling child from London. On Wednesday I received 1 copy sent down by Faulkner." I just think it's really gorgeous that she describes it in that way, isn't it? Like, I received my own darling child from London. On Wednesday, I received 1 copy sent down by Faulkner. She talks about some other copies. She then writes about, "Miss Benn dined with us on the very day of the book's coming, and in the evening we set fairly at it and read half the first volume to her, prefacing that having the intelligence from Henry that such a work would soon appear, we had desired to send it whenever it came out. And I believe it passed with her unsuspected. She was amused, poor soul, that she could not help, with 2 such people to lead the way. But she really does seem to admire Elizabeth. I must confess that I think her," meaning Elizabeth, "as delightful a creature as ever appeared in print. And how I shall be able to tolerate those who do not like her, at least I do not know." And I suspect that's a feeling that we all have. If you don't like Lizzie, you probably should leave. She goes on to write, "The second volume is shorter than the first, but the difference is not so much in reality as I look, there being a larger proportion of narrative in that part. I've lopped and cropped so successfully, however, that I imagine it must be rather shorter than Sense and Sensibility or S&S altogether." I think it's really beautiful, 1, how she describes it. 2, as you read through her letters, you see that she calls Pride and Prejudice P&P, and most of us in the audience probably call it P&P as you go, as we discuss Pride and Prejudice. So this particular volume, Pride and Prejudice, as I said, was published, or if I didn't say, was published in 1894. It contains many illustrations. The preface to this edition was written by, oh, there's the front page, isn't that beautiful? It was published by George Allen, and illustrators, I've said, and I'll speak about him in a moment, by Hugh Thompson. Most of Hugh Thompson's works were actually published by Macmillan. If we go back a slide here, no, we're going too far the wrong way. Hold on, don't look at that. You'll see in this slide, the 2 on either side were published by Macmillan and Company. The one in the middle was published by George Allen. George Saintsbury wrote the preface to this edition, and he was a prominent literary critic and academic in the late 19th and early 20th century. In addition to being a professor and a literary critic, he was very well known and still known as a wine connoisseur and author of Notes on Cellar book, which is still available. His introduction contains two interesting observations, one that still rings true and one that probably couldn't be much further from the mark. He begins his preface by observing, Walt Whitman has somewhere a fine and just distinction between, quote, loving by allowance and loving with personal love. This distinction applies to books as well as to men and women. He goes on to say that Jane Austen is accordingly one of those not very numerous authors that is loved with personal love. And I suspect there's many members of the audience that can really relate to that. We can see probably by the attendance how many people love Jane Austen and her works with personal love. And it's in this preface to this edition that the term Janeite is first used. You'll see it about halfway down the page. Until I started my research for this lecture, I wasn't aware that there was a description for fans of Jane Austen. And even less aware that there were two terms, Austenites and Janeites. How many people knew that that was the case? Yep, okay, got some fans here. So, let's be clear about them. You either fall into the camp of Austenite or Janeite. As Rosa Garcia Periogo explains in her essay, Traumatised by Jane Austen, Janeites and Austenites on Screen, she says the squabbles between Janeites, amateur readers of Jane Austen, and Austenites, professional readers of Austen, are long-standing. Referring to Jane Austen by the first name, as if the author were a friend, or by the surname, equating the writer with great male authors such as Shakespeare or Dickens, has caused a rough battle amongst Jane Austen devotees. It's something that you can discuss at your leisure afterwards. So I'm going to put my flag up and say I'm in the Janeite camp. I just love her stuff. And I wouldn't describe myself as an Austenite. He describes it, and you'll see the word there, as a sect. You might also recognise that as describing you. His second observation couldn't be much further off the mark. He wrote, I do not know whether the all-grasping hand of the playwright has ever been laid upon Pride and Prejudice, and I dare say that if it were, the situations would not prove startling or garish enough for the footlights, the character scheme too subtle and delicate for pit and gallery. About 130 years since he wrote that, he's been proved wrong many times. In fact, he was proved wrong the following year. 1894 was the preface, 1895 was the first time that Jane Austen's Pride and Prejudice was turned into a small play. But it would be unfair to his reputation as a critic not to refer to his next statement about possible adaptation of the work. He said, but if attempt were made, i.e. by playwrights, it would certainly not be hampered by any of those loosenesses of construction which sometimes, disguised by the convenience of which the novelist can avail himself, appear at once on the stage. So let me turn to the illustrations that we have. There's a beautiful one by Hugh Thompson. When this book was published at the end of the 19th century, as I said in 1894, the 19th century has been described as the golden century of book illustration. When Pride and Prejudice was first published at the beginning of the century, or relatively at the beginning of the century, books basically didn't have illustrations. But over the course of the century, books had more and more illustrations. In the middle of the century, the first illustrated newspaper was published in the world, was published in Britain, and more books had illustrations in them. This edition was illustrated by the prominent Victorian-era illustrator Hugh Thompson, who was Irish by birth, but he spent most of his time in England. Prior to illustrating Pride and Prejudice, he had illustrated The Vicar of Wakefield and many illustrations in the English Illustrated magazine. Pride and Prejudice was the first work that he'd arranged on a royalty basis. He started work on it in the autumn of 1893 and completed a total of 160 drawings in the time for the volume to be published in October of 1894. His biographers noted that public appreciation of the Pride and Prejudice is shown by the fact in the 12 months 11,605 copies had been sold. 3,500 were sent to America, and by 1907 no fewer than 25,000 copies of the edition had been printed. So have a look at Project Gutenberg later on and have a look at the illustrations. One of the really interesting for me because I'm a kind of a person, interesting things about the illustrations is if you go through the century, in the early part of the 19th century there were kind of stock standard illustrations, but people like Hugh Thompson and other illustrators spent a lot of time to make sure that their illustrations were relatively accurate for clothes, etc., from the particular time. But before I talk about our modern responses to Pride and Prejudice, I want to mention its long history as what we might call a therapy book, or perhaps just a book that sparks joy and happiness. Lizzie Dumford, the director of Jane Austen's house in England, writes in Darling Children, The Presence of Pride and Prejudice at Jane Austen's House about her favourite first editions of Jane Austen. And she acknowledges that it's a bit of a privilege to have favourite first editions of Jane Austen's Pride and Prejudice. But she picks one particular copy, and it's not one of the copies that had been owned by Jane Austen. This is an image of some of the writing in it. Carol, it's in pencil, and it's not our copy anyway, it's a first edition. But what it is the annotations by a reader. She notes, that is Lizzie Dumford notes, it's a record of all the times that this reader read and reread and finished the book. October 7, 1904. Then again on June the 12th, 1907. And again on August the 1st, 1909. And this reader read it aloud on March the 3rd, 1910. But most poignantly, again, whilst on leave from the BEF, 5 May 1918. The BEF, as she explains, and I quote, was the British Expeditionary Force, which means that the reader was male, as we could have possibly suspected from the affinity, as he writes in his notes, with Mr. Bennet, and that he was in active service at the front in the First World War. For this reader, as for so many others across the decades, but particularly in times of conflict, Pride and Prejudice represented an escape as well as a vision of an idealised England. Bibliotherapy, that is, the prescribing of books as a therapeutic response, has been around since ancient times. But as a term, it was coined by an American writer in the midst of the First World War. In the United Kingdom, H.F. Brett Smith was credited with developing a, quote, fever chart of therapeutic books for shell-shocked soldiers and soldiers on the front. At the top of the list was Pride and Prejudice. Special editions, called force editions, were printed for soldiers at the front and at home. So each of us will have our own personal favourite parts of Jane Austen's work, and I could, of course, devote this lecture to themes of love, marriage, flirting and unwise choices, but the theme was supposed to be about lawyers and making them happier and better. But love, marriage, flirting and unwise choices are probably something that most of us in the room have done or hope to do at some stages of our lives. But for now, I'm going to suggest some central themes that I'd like to take out of Pride and Prejudice for law students and for lawyers, that they can gain particular value from them. One is the importance of understanding oneself and understanding others. Another one is about being prepared to change one's mind in the light of new evidence. Another is standing up in the face of authority. How many of you can remember Lady Catherine? And finally, brevity. So I'm just going to mention some of those points as we go, and looking at the time, I will read reasonably quickly some quotes from P and P. Do you remember when Elizabeth and Darcy were in the drawing room and Miss Bingley was there trying to get Mr. Darcy's attention, making all of the noises and doing all of those things and getting them to walk around the room so they could show each other's bodies, so to speak, but of course clothed. Anyway, Darcy goes on, it's been the study of my life to avoid those weaknesses which often expose a strong understanding to ridicule, such as vanity and pride. Yes, vanity is a weakness indeed, but pride, where there is real superiority of mind, pride will be always under good regulation. Elizabeth turned away to hide a smile. Your examination of Mr. Darcy is over, I presume, said Miss Bingley, and pray, what is the result? I'm perfectly convinced by it that Mr. Darcy has no defect. He owns it himself without disguise. He goes on to say, I won't read all of it, but you will remember this line. My good opinion, once lost, is lost forever. That is a failing indeed, cried Elizabeth. Implacable resentment is a shade in a character, but you have chosen your fault well. I really can't laugh at it. You're safe from me. There is, I believe, in every disposition a tendency to some particular evil, a natural defect which is not even the best education can overcome. And your defect is a propensity to hate everybody. And yours, he replied with a smile, is wilfully to misunderstand them. Do let us have a little music, cried Miss Bingley, tired of in a conversation in which she had no share. Louisa, you will not mind me walking, Mr. Hurst? Her sister made not the smallest objection, and the pianoforte was opened. And Darcy, after a few moments of recollection, was not sorry for it. He began to feel the danger of paying Elizabeth too much attention. You'll remember when she finally got the letter. I'm just hoping everybody in the audience has read Pride and Prejudice. Really terrible if I'm... Should have put a little spoiler alert. There's a guy called Mr. Wickham. We'll just leave him aside for the moment. But if you can remember when she got the letter about Darcy and his explaining Wickham's character and the reason for his response. And she grew, as Austen writes, she grew absolutely ashamed of herself. Of neither Darcy nor Wickham could she think without feeling that she'd been blind, partial, prejudiced and absurd. How despicably I have acted, she cried, I who have prided myself on my discernment. Pleased with the preference of one and offended by the neglect of the other, on the very beginning of our acquaintance, I have courted prepossession and ignorance and driven reason away where either was concerned. Till this moment, I never knew myself. I thought that was a really beautiful part of the book. It's really explaining to us she's been wrong. She hasn't thought about herself, and now she has. Not a bad lesson for us as lawyers and humans and law students. I'm conscious of the time. I'm going to talk briefly now about a couple of other things. So one is her comments about Darcy and Darcy's comments about the people in the country. And the reply, but people themselves alter so much that there is something new to be observed in them forever. And I love that also in the book, the idea that our ideas of people can change and we should reflect upon them. I've mentioned Lizzie's responses to Lady Catherine. I reckon that's one of the best parts of the book, where she really stands up to authority. It's an important part for students. And I'm almost finished. One of my favourite parts, which I laughed out loud about, and I often do, is Mr. Bennet's letter to Mr. Collins in response to Mr. Collins's always long-winded letter. Mr. Darcy's letter to Lady Catherine was in a different style, and still different from either was what Mr. Bennet sent to Mr. Collins in return for his last. Dear Sir, I must trouble you once more for congratulations. Elizabeth will soon be the wife of Mr. Darcy. Console Lady Catherine as well as you can. But if I were you, I'd stand by the nephew. He has more to give. Yours sincerely. Brilliant. So, just to finish off, I think the most profound way that we can use Jane Austen to make lawyers and law students better and happier is to remind us to watch, listen and understand the complexity of human behaviour. Needs, loves, wants, prejudice and pretensions. Reading Jane Austen immediately transports the reader into the world of her characters. They speak to us as if they are alive. She reminds us to take time to understand others, to cultivate empathy, emotional intelligence, self-knowledge and creativity. But if that sounds like a lot of hard work, I just say read Pride and Prejudice for joy. Joy is what Pride and Prejudice has brought me and millions of other people since it arrived as a darling child on the 28th of January 1813. Thank you very much.